Would request all the dignitaries to please come on dais. Would request our chief guest, Shri Ashok Chawla ji, to please come on dais. Would request our Central Council member, Mr. Satvinder Singh, to please escort him to the dais. Mr. Atul Mehta, President ICSI. Mr. MS Sahu, Member Competition Commission of India. Mr. UC Nata, Member Competition Commission of India. Mr. AS Chandio, former ASG. Big round of applause for all our dignitaries for sparing me the valuable time in the morning and coming here. Thank you, sirs. Mr. Ashok Chawla, Chief Guest for the day. Honorable Chairperson CCI, Mr. UC Nata, Member CCI, Mr. MS Sahu, Member CCI, Mr. Atul Mehta, President ICSI, Mr. AS Chandio, Senior Advocate and former ASG and keynote speaker for this inaugural address, Mr. Satvinder Singh, Central Council Member, Mr. Manmohan Juneja, ex-ROC and now Additional Director General Competition Commission of India, Mr. S.P. Narang, past Secretary ICSI, Secretary CCI, Manoj Bhargavji from Corporate Law Advisor, Mr. J.K. Bareja, senior members and friends. Good morning. Thank you for responding back. I, at the outset, welcome you all and welcome all our dignitaries also present on the dais to our today's seminar on competition law and compliance, a growth enabler. The idea of having this seminar was brought to my mind by one of the members only, almost couple of months back, when ICSI organized a similar program in Calcutta. And the chief guest here, Honorable Chairperson CCI, was the chief guest at that program as well. And the mail was sent to all the members across the country. So one of our members sent me a mail that when can we have this kind of a program in Delhi. So that was the feedback I got and that was a request. And after knowing that yes, members would like to come to this kind of a program, I requested our own Mr. MS Sahu, who is past Secretary of ICSI and presently Member Competition Commission of India, to help us with this, designing the entire program, help us with bringing all the luminaries to this program. And when I called him up, he said, come. He's always, when he was past, he was Secretary ICSI at that time as well. I remember at that time I was Secretary NIRC. And when I called him up that time for the first time, he did the same thing. Come on NPS. So from there I thought that yes, we need to organize this program and we need to have discussion on it. In fact, our curriculum already has this subject, Competition Commission and Competition Law. So we need to motivate our members. And when I discussed with Mr. Sahu and Ms. Chawla that we need to have this kind of a program so that we can inculcate the knowledge and the basics of this law in our members, which will surely help them to plan their career and focus to have this as a practice area as well. In fact, sir, I would like to share when this program was planned, I went to Mr. Sahu and then discussed what should be the theme. The theme was planned. After planning the theme, when I came back and thought that who all can be requested to be the speakers, at that stage itself, I thought we need to have more of our members joining as speakers. That's why we have chosen people who are company secretaries and who are practicing in this field. So that at least the idea and the point that yes, we can practice this area and we know this subject is propagated. So to begin with today's seminar, friends, would request our President ICSI, Mr. Atul Mehta, to please present a flower bouquet to Honorable Chairperson,
Shri Chandyo, Shri Atul Mehta, my colleagues, Mr. Nahata, Mr. Sahu, distinguished office bearers and members of the Institute of Company Secretaries, ladies and gentlemen. Let me begin by complimenting the Institute in conducting the series on, amongst other things, competition law as a process of continuing education, which is extremely important. Not just from your point of view, but equally from the point of view of the Commission, because this helps us in outreach to professionals who are vital links in changing the corporate governance paradigm in this country. I'm also thankful for your invitation to be here this morning. But I must say, you've been very unfair because you put me after Mr. Chandyo. Such an inspiring and articulate speaker. I think no person who has been a babu all his professional life and is now very tentatively sitting for some time on the other side of the bench can compete with the eloquence which Mr. Chandyo brings to all that he does. And it's not just eloquence, it's the wisdom of all the grey hairs which he says he finds not so much in abundance in the Supreme Court or the High Court. Ladies and gentlemen, competition or competition law or competition principles have a meaning only if we are dealing with a regime which is somewhat open, which is built around the market and not built around a control system. If we were, say, in North Korea or Cuba, we would probably not be talking of, because there would be no competition, there would be no market, there would be no competition, and therefore there would be no need for a seminar of this kind on what is competition law, what are its principles, and what do we do with it. It probably was much less relevant or of hardly of any relevance before 1991, even in our own country. And the young in this room would not be familiar, but all those who have spent a long time watching the change in the economic landscape over the last 40 years know what the situation in the marketplace in terms of goods and services was before 1991. There was only one company to turn to get a telephone. If it worked, you were lucky. If it didn't work, you had to rely on the most important person in the neighborhood, which was the linesman, to come and fix it. If you needed transport, a two-wheeler, you had to stand in a long queue, a waiting period to get a scooter, which when it came was the apple of everybody's eye in the neighborhood, because it came after such a long wait. Similar with cars, there were only two models. If you had a choice, it was between X and Y and nothing more. And today, you know what the situation is, where page after page of newspapers is filled with advertisements of different models, different makes, different specifications, different kind of deals and bargains. If you needed to travel by air, there was one airline. In 1994, the skies were not open. All that has changed in the last 20, 25 years. And therefore, the change has benefited positively the growth impulses. There's clearly a positive correlation between efficient and working markets on the one hand and GDP growth on the other. And therefore, the change in the GDP story from about 4%, maximum 5%, 20, 25 years ago, to on an average about 8%, 7.5%, 8% in the recent past. That's the paradigm change which has come about. And it's come about by virtue of competition in the marketplace. So it's all a very good thing. What has happened to our ecosystem. But as was mentioned, there is the need for, and that's what Parliament felt, that's the wisdom around the world, there is need for an umpire who watches that the state of play in the market is generally according to accepted rules, that somebody is not being pushed out, somebody is not being bullied, and that it should go like Mr. Chandok, person may be dominant but not abusing his dominance. So those are the principles which need to be carefully watched. If there are violations, then the umpire is supposed to, as in a game of football, hold up either a yellow card or an orange card or a red card to identify that somebody is playing foul. So that's the act which Parliament brought about. And as you may have seen, it's in a way a very small act. You know, in India we are used to long-winded, elaborate legislations. I don't know whether that's really desirable or not. But this piece of legislation is very short, not more than about 50 pages. 66 sections in all. Quite unlike what our normal draftsmen put out. But it's at the same time not all that simple. It's partly complex because it's at the intersection of law and economics. So you have to marry the two and see how things are working, how to interpret them legally and judicially. It's also about behavior. Except the parts relating to mergers, acquisitions. The other side, which is really the enforcement side of the Act, is to see what are the agreements, whether something is going wrong, whether there is a cartel or not. So essentially it is judging, appraising behavior, economic behavior. And behavior, as you would appreciate, is not all that easy to slot in either black and white. There are lots of shades in terms of behavior. And what may seem wrong at one point of time may not be wrong 2 years down the road. What seems wrong to somebody, what seems wrong to a mother-in-law may not seem wrong to a daughter-in-law. So these are the nuances which the law has to take into account, and which is what makes the job both in terms of what the authorities of the regulator looks at and also in terms of what the professional stakeholders, advisors like you, have to judge and look at, makes it complicated. And therefore, it's very important that there is built into the system a fairly elaborate system and well studied, well-prepared system of compliance. Because corporate enterprises operate at all levels. It's not just the CEO or the board, but it's at the level of the marketing managers and the sales managers and the materials managers where problems could arise. And therefore, when it's mentioned that there is, a lot of corporates don't know or they're not aware, and even those who are aware are not aware down the line. So it's very important that there is a body of compliance which is built up so that ultimately prevention is far better than any kind of cure or any kind of enforcement and penalty under the Act. And that's where professionals such as those who are members of this institute have a very vital role to play, because you are at the forefront of advising the entities that you deal with in terms of compliance programs, in terms of a well-structured thing, in terms of ensuring that it's actually not just in letter but in spirit, it goes down the line, and that therefore corporates are better prepared for eventualities. Because otherwise, and this is what the Parliament has given us, the Act is fairly robust. It provides for fairly hefty penalties, which can go up to 10% of the turnover, which can go up to including 10% of the profits in a particular year if it's a cartel, because cartels are supposed to be the most worst kind of violations of competition law. So penalties, and the Commission or whoever sort of adjudicates will naturally have no option but to impose those penalties. But penalties, in my view, are not the end objective. Those are doses which are administered to the enterprise and partly as a kind of signal or a message to others. The actual objective has to be to ensure that there is better compliance and that there is, therefore, the issues are taken care of and they don't really erupt to the extent where there is need for enforcement and high penalties. The other matter where the law or this whole business becomes complicated is because the world is moving so fast. And markets are not remaining the kind of markets which people of our generation are used to. They are not markets which operate in the manufacturing sector, brick and mortar, so on and so forth. Markets are dynamic, technology is coming in, there are new platforms which arise, there is this whole issue which was mentioned of standard essential patents. The interplay of intellectual property, which is a huge thing and is going to become very important in the years ahead. The interplay of intellectual property in relation to competition principles, in relation to corporate governance. So the whole paradigm is shifting, and it's shifting very, very fast. So there will be need for new ways in which to appreciate what is happening in the marketplace. And maybe at the end of the road, there will perhaps be need to, not just in India, but across the world, maybe at different points in time, because countries are at different stages of economic development, but need maybe to rewrite some of the legislations which govern these principles which are changing so fast on intellectual property, competition law, etc. There's a whole lot of, and people call it, earlier they used to call it creative destruction. What Schumpeter called creative destruction, where some companies go out, the body gets established, and that's, I think, it's been handled well by my by those who came before me and my colleagues in the CCI. But we have of late, in addition to the enforcement, we have again tried to reinforce the advocacy and communication platform and re-energize it through various new novel methods, so that we can, in addition to doing the enforcement, also reach out and ensure that the communication is not lost, that the gaps don't continue to exist for very long. Because it's unfortunate if maybe 7 or 8 companies know that there is a competition law and yet violate it. But 2 companies are violating it maybe because they don't know. That's unfortunate. So we have a role to play there. You all have a role to play. And I'm very happy that we are able to play this to mutual advantage and to the benefit of the entire community of stakeholders. With these words, let me once again thank the Institute and wish this seminar and many more that will come in the future the very best. Thank you.
Thank you, sir, for acceding to our request. In fact, I don't know whether I should share when this request was made by a member to please do this kind of a program, and specific mention was made, kindly get and request the chairperson CCI to be there. I said surely we will try so. And the comment which I got back was that he will surely accede to your request. He has already acceded to similar requests. In this case, surely he will accede to your request, because the request will be made by one Chawla to another Mr. Chawla. That's why. And that was on the funny side what he said, but that was true. Mr. Chawla acceded to our request. Would also request our Central Council member, Mr. Satvinder Singh, to please present a flower bouquet to Mr. M.S. Sahu, and request you all to give a big round of applause for Mr. Sahu. Would request Dr. S.P. Naran, past Secretary, ICSI, to please come over and present a flower bouquet to Mr. U.C. Nata, member CCI. Mr. Nata has been well-wisher of our profession for long, when he was regional director and thereafter as well. Big round of applause for Mr. Nata for doing, although he was busy, but he said surely I can come for some time in the inaugural. Thank you, sir. We request Mr. H.S. Grover, past chairman NIRC, to please come and present a flower bouquet to Mr. A.S. Chandyok, senior advocate and former ASG and keynote speaker for this program. Thank you, Chandyok sir, for agreeing to our request. How many members would be interested to know in detail about this law? But I'm happy to see the number of members who sent their confirmation to us. And when we discussed about the theme, we thought we need to bring in this compliance part into the theme itself. Because conventionally, we are known as compliance specialists, although our role has now evolved from being a compliance specialist to now being a corporate strategist. But still, compliance is our forte, and we don't have to leave it. And compliance has gained a lot of importance, particularly in this new law, in the changing strictened corporate governance regime. We need to be sure of all the compliances, and particularly this competition law. We need to really know about this subject. We need to really educate the industrialists. We need to educate our promoters about it. Because I have seen, despite the fact that Competition Commission of India is in force for the last 6 years, and heavy penalties have been already imposed, as every one of us know about it. But still, the industrialists are not aware about the implications, the orders already passed, as to when they should not cross that threshold or that borderline of being in a dominant position or abuse of dominant position. So, considering that in mind, and particularly the compliance regime which is there in this competition law as well, we thought to have this program. And in fact, these sessions are also planned in a manner that we get a full knowledge, not only about the theme, but also about the ingredients of competition law and the compliance as well. To begin with, would request Mr. Satvinder Singh, Central Council member, to please come and share his address.
Yes. Uh, Honorable Chief Guest of the Day, Chairman CCI, Mr. Ashok Chawla ji, our own member and the person who we always believe that he was always in the forefront of ICSI, and our past secretary, and now our honorable member of CCI, Mr. M.S. Sahu. The person we can feel proud, who is chairman of the Institute's Quality Review Board, and who is so much involved into the Institute activities, and we feel proud that he is also a member of the Institute of Company Secretaries, Mr. U.C. Nata, and he's member of the Competition Commission. My inspiration, my elder brother, but not, I would say that what I've learned is, and I would say who is darling of at the Delhi High Court and remained president for a number of years and every time won with highest votes, is Mr. Amarjit Singh Chandiok, the senior advocate, President ICSI, who is the inspiration behind all the members to get more and more programs of the quality programs, Mr. Atul Mehta, Madam Smita Jingam, IRS and Secretary CCI, Mr. Manmohan Juneja, who was the Registrar of Companies Delhi and then moved to MCA, and we feel proud that he has been moved to now on deputation to CCI as Additional Director General. Dr. Narang, Mr. Grover, other dignitaries of the dais, ladies and gentlemen, a very good morning to all of you. It is indeed a pleasure that we are hosting a program and the Chairman CCI is here to grace the occasion and to bless us and share his words of wisdom along with the other dignitaries on the dais. I think there are certain few things which I would like to place. If I recall, because that time Mr. Bhatia was there as registrar and I was interacting more with Mr. Bhatia, and ICSI was the one who was coordinating more when CCI was to come into play, that what kind of research we can do. And I think ICSI was assigned the job to do the research and to do how best the advocacy can be done. I am happy when I see the side of CCI every time that more and more advocacy programs are being done, and this is the one program I would say it is in line with that. I think, but sometimes I feel that why the members are not participating and you see going to CCI and making it, that's a one area where one has to see to it, given the fact that the kind of economic legislations which are in the curriculum of ICSI, perhaps no other academic program and no other qualifications can have that sort of economic legislations. And I personally feel that the law and economics are so intrigued, and particularly when I would say that you have to appear before CCI and you have to argue before CCI, I think economics is the one which plays an important role. And I feel that somehow my personal feeling that secretaries are rather more submissive in nature. They may not be having that articulation that okay, how best, that's where we have to really work upon it. But given the, I would say, the academics we have, I think we can easily come over out of that hesitation, and that is only thing. I think Mr. Chindu can vouch better that how much pain this practice area is, where even the competition law, if you can practice, that can be done. But no doubt about it. I'm happy that this is the one side which you go to this thing where the company secretaries have been recognized as the experts. They can make it. And I feel proud that some of the company secretaries have been taken by the CCI, but kind of expert fee and the professional fee based on that, this thing maybe in 2009 that was taken. If the chairman feel that okay, that's the minimum remuneration which is designed for those experts, if that can be increased, I will be happy to that extent. Competition assessment of deals legislation that where the CCI has invited the institutes. Sir, we would like to come. I will request President if we can just make a visit for this. As I said, it was the ICSI who was doing all the backup work at one point of time, doing all that research, and we will be happy to be involved for the competition assessment deals where we can really support the competition commission that how best we can just work it out and we can take it forward from this. I think the one or two issues to the members, as NPS has said, that it is the compliance which has to be seen, and more so I am saying that the kind of penalties the corporates also feel scared, the kind of definition of even the agreement which is provided for this thing is that even any understanding, whether formal or informal way or any action, or whether that agreement is intended to be enforceable by legal proceedings or not, that is a separate issue which I think the connotation of the word agreement which is given in the act, it is so wide that you never know that how this, your action can be construed as against the, though there are only 4 sections, I would say section 3, 4, 5, 6, which place, but such an important decision, you look at various decisions which have been happened, be it, so whether it is a horizontal agreement or a vertical agreement, you are talking about a predatory pricing, you are talking about the cartelization, whether it is abuse of dominance or not, then what is the relevant market, all that are so important not to be considered, to be discussed. And for that matter, I feel that some training program is required, not only for the members, but even for the corporates. And sir, if you permit us, we will come to you, we will present it, that how the Institute of Company Secretaries can associate with CCI to do that training programs, even for the corporates, even for the members, so that that compliance management, if that happens, I think we can really do the wonder, because I feel that CCI is such a growth enabler for the economy, for this. Be it, I've seen your decisions even for the government undertakings, be it Coal India, be it ITPO, be it that the insurance policies which was being taken up in Kerala. So all those issues probably we can just work it out. I'll not take much of the time for this, but I am sure that okay, if we join hands and if we start working on the compliance management of this thing, it is good both either in service or in practice for the members, but for the economy we can really work and we can contribute a lot to the economy for giving this for the purpose for which this CCI has been established. Thank you so much for this.
Thank you, sir. Our President for his presidential address, Mr. Atul Mehta.
Today's guest, Chief Guest Sri Ashok Kumar Chawla, Chairman Competition Commission of India. Keynote speaker Sri Amarjit Singh Chandiok, Senior Advocates and former Additional Solicitor General of India. Sri M.S. Sahu, our own man. The member and U.C. Mehta, the member of Competition Commission of India. My council colleague, Sri Satwinder Ji, who is present here. The young and dynamic NIRC chairman and my very good friend, the NPS Chawla ji, and all my friends who are sitting here. Good morning to all of you. This is the third programs in the series. We already had 2 programs of this similar kind in Bombay and Calcutta, and this is the third program, and there are a couple of more programs being lined up across country. The idea is to sensitize this competition act across country. Friends, for any orderly development of market, you require good antitrust law. And in India, this trust was passed sometime in 1969, and then it was amended sometime in 2002, and then it was enforced sometime in 2007, and of course the commission was notified sometime in 2009. Now this commission is almost completed 6 years now, so it is one of the things. It also regulates the combinations, it has also extraterritorial reach, and covers both goods and the provisions of the services. It has a right to fine, it has a right to intervene, and of course it has a lot of power under the law. Friends, I think in our day-to-day life also, you also face a lot of competition as an individual, as a corporate professionals, and even the company also. But you need some regulators who make sure there is an orderly development of the market. We see there's like there is always the conflict between the Apple and Samsung about the technology. So all this company, they always wanted to be. Now it has been said that every business wants to become a monopolist, and of course every consumer wants the competitions. And if you have a competitions, there are many advantages, like you have innovations, you have more productivity, and there is always a cost reduction also. Of course, you also have the sector regulator also. Now we have a TRAI for a telecom regulatory authority. You also have electricity regulatory commissions. You also have a Reserve Bank of India. You also have IRDA, Port Authority. Now, those the sector-specific regulators, they are very focused on their respective industry. But as a CCI, they probably cover the whole market. Friends, of course, the CCI has also came out with the compliance management book also, which is available to the public also. So, as a professional, as a company secretary, I think all of us we should be going through it. Now, before I conclude, just wanted to give you some kind of a statistic which I picked up from the ENY research report. It says more than 80% of our Indian enterprise are unaware about the competition law. Of course, now this has been reduced, but many of our Indian enterprises are still unaware about this competition law. And as an ICSI, we are joining in the hands with the Competition Commission of India to propagate the act across country. And it also, the research also said that 70% of the respondents believe that the Indian enterprise do not have a control mechanism, and the documents such as vendor contracts, supply and distribution agreements are not verified at the grassroots level for the compliance with the competition law. Now at the same time, the MNCs, most of the MNC, they have a proper systems are in place. Probably they understand this competition law better than the Indian enterprises. And it also said that the 75% of the people believes that if the commission is more active, there will be more compliance of the laws also. So friends, there is a need for us also as a company secretary, we are the one who understand this law, compared to any other professionals, and of course it's there in our curriculum also, that we should be propagating. We are in with the this commission also, so we are doing a lot of programs, and this program is also one of the programs where we have the best of the speakers in this antitrust law. With this, I conclude my speech. Thank you very much.
Friends, now it's time to listen to a great speaker, Mr. Amarjit Singh Chandiok. In fact, when I requested him, I was wondering and I was thinking, we are having a program on competition law, and here we have our keynote speaker who has no competition in his advocacy skills, and I mean, I have not seen him and hardly seen anybody competing him actually. It's my pleasure and great learning experience whenever we go to him and brief him. Request all of you to give a big round of applause to Mr. Amarjit Singh Chandiok.
Chawla. I was wondering after you said that, and with Honorable Chairperson himself present with two honorable members, I hope I don't get a show cause tomorrow morning in a competition. It's a great honor for me. Let me start by saying that one rarely gets an opportunity, and I must thank the Honorable President and Mr. Chawla to give me this opportunity. I keep saying this, and I want to repeat before you. Whenever one sits on a podium with people who actually know the threadbare of that law, it makes you very insecure. God never gave me that opportunity, and I keep saying that I should share the podium in the court in CCI. But look at the blessings of his, that both Mr. Mehta and Mr. Chawla gave me this blessing to sit on the podium with the chairperson and two eminent members of the CCI. That itself is a great honor for me. And then to address an august gathering like you, I don't think I even deserve to be called a keynote speaker. I will remain an infant at law at even the last leg of my life, because law is learning, and one who stops learning can't be a lawyer, to my mind. And I remind you of a very eminent Chief Justice of India. I was actually a visitor to the Honorable Supreme Court, and counsel made a submission, and another counsel jumped from the other side and said, Lordship decided this case last week and passed on a judgment. And I saw the Honorable Chief Justice putting that judgment upside down and said, when did I stop learning? Maybe he has something to say, let me hear him. It is a great pleasure to be amongst you, to see in a learning process of what competition law is, and that too to be addressed by the chairperson himself, who has been responsible for bringing, I would say, ironing out many creases of the competition law, along with the honorable members here, to see how the industry can work better. Though we find competition law had a very birth which took place, a wrangle between the Supreme Court and the legislature. Till the 2009, the Act got notified after 15 years of MRTP Act. But laudable was the legislature's endeavor to bring to us this cocktail of economics and law. The economy of the country, as we all know, has been shifting from one force to another. It oscillates every morning. Many of us, and Satwinder in particular, I know, has been oscillating in the share market to see what's happening all around. But the question that arises, and I begin from there to request you to consider that the foundation of this law needs to be addressed. Why did we first make this law? Where was the need for this law? Where was the need for this regulator? We had a MRTP Act which functioned for 15 years almost. Then where was the need to do so? But the need came because, with all humility at my command, the enterprisers, the industry, the businessmen thought this desh mein sab chalta hai. We needed a regulator who would tell us, by interpreting the provisions of the statute, as to how you move. Because more you have competition, the ultimate aim is to provide something to the consumer. And I always say this, that when you have blending of these two situations of economics and law, you have a situation where you are able to bring before the people something better. So Mr. Chawla said, I don't have competition, but I must tell you, the more I see youngsters coming at the bar, I feel I should have been born later. They are more equipped. They tell you something out of the box, which probably you never thought about it. And the fundamentals of this law, in my humble submission, would be to all of you to consider what is the basis of it. The basis starts from an agreement. And again, with all humility, I find most of us write our agreements on computers, not by our computer brain granted by the Almighty brain, God. Most of us go to a model agreement, cut and paste that, and start looking at it, without realizing that the laws may have undergone a change. There could have been a change yesterday. Look at the historic judgment that came yesterday by a constitutional bench of the Supreme Court, striking down a constitutional amendment, saying it's a basic structure of the Constitution, being the independence of judiciary. If people will go to, I could only read few pages this morning, I think page 7 or 8, Justice Kamleshwar, who is actually dissenting in that judgment, writes a beautiful passage on what should be a learning process for an executive, legislature, and also judiciary. Therefore, the agreement is your basis. If your agreement takes care of the compliances of all laws and ensures that you do not in any way, notwithstanding, and I have said that earlier too at many occasions, dominance per se is not attracting competition law. The fact that I am able to monopolize per se is not bad, because I must have, my ability must be there to monopolize it, but as long as I'm not abusing it. The abuse is the process that is coming at our way. Therefore, how do we carry that abuse away is the question that we have to address ourselves. And if we carry that agreement to ensure that there's a compliance of every provision of law, I don't think much will be left for the regulator or even to DG to investigate into that whole thing. The whole problem comes in that I look at, if I'm a new person in the industry, I look at A, B, and C, take those agreements into my stride, put them into my computer, and make another agreement. An argument was raised at one time in one of my conferences with my colleagues, saying that if I'm a new person, how would I make a separate dent in the market? Well, if your agreement is compliant enough, you may be able to give an incentive to somewhere else to attract customer to you. And I always say this, your own skill, whether you're a businessman, your own skill, whether you're a professional, today or tomorrow, will attract people. We don't advertise, for example. Still people come to you. Why? Because your skill is important. Your reputation in the market flows. A lot has been said by people, and a lot will be said by all of them. They will iron out the creases of what we see in the competition law today. But my fundamental request is that we must start with the fundamental is the agreement. And if we look at the agreements and we find those agreements are compliance of all law, the regulator will not be able to look at it. The problem that we face today is that in the garb of monopolizing, and who doesn't want wealth? Each one of us wants it. Each one of us wants to have the maximum possible share in the market. But as long as I am ready to provide that fundamental competition in the market, everything else will be fine. Where did cartelization take place? In fact, I find recently a new phenomenon has come. And there I don't know whether the Competition Act will really apply to us or not. We all have started now bidding. The PSU has started asking lawyers and company secretaries to bid. And we have started bidding now, that I will do cases at a particular fee. Now, what is this competition? Competition can't be with respect to a bidding process of money. It has to be my skill. So the first request is that we must see whether we are able to achieve that fundamental agreement. And the request would be that the agreement must come from what the God gave you, the computer, your brain. And I can assure you, what God gave you as a computer, nobody can substitute that. No science will be able to do that for you. And for the compliance programs, one looks at, and I'm sure during the course of your technical sessions, you'll see these abbreviations coming, 4 Rs, for example. Risk identification, risk assessment, risk mitigation, and then comes review. Or alternatively, you may have 5 Cs, commit commitment in leadership, culture, compliance know-how an organization, controls, and constant monitoring. What is this constant monitoring would mean only the change of law, change of compliances must come in as and when you want them to do so. Because unless you do that, you can't have anything else in the agreement to go through. What unfortunately, right from my own view, is we have lost sense of governance at all. Whether I go to the parliament, whether I go to the executive, whether I go elsewhere today. I don't think in my career I've ever seen parliament behaving the way I see parliament today. I don't think the executive behaving the way the executive is behaving today. And with all humility, the honorable members and the chairperson would excuse me. I've never seen this kind of judicial system. The judges acting in the manner they act today. The problem is again the same, that we have stopped blending ourselves. The regulator or a court must blend with the person before it, whether it's an entrepreneur, an industry, or even a lawyer or a company secretary arguing. We must blend to ensure that's the job that the court gave us. We must ensure that what we are doing is in the common interest of a consumer. And let me give a very hard example of it, which is totally my personal opinion, notwithstanding that I was the law officer of the country, and I was the one responsible for, to some extent, the establishment of 2G, what you see today. The court would have looked at it, that notwithstanding that the licenses should have been cancelled, but over the period of years, they have created infrastructure, they have created industry, they have created jobs, they're feeding people. And let me give you an example of a Unitech, for example, one of the persons whose license has been cancelled. Why the court could not stand up to say, please put me on an affidavit, what kinds of areas do you own in any part of the country? And look at the requirement of that country, look at the requirement of that state and provide institutions like schools, colleges, hospitals, instead of just cancelling those 122 licenses, then extending it for 1 year by its own order and creating this chaos. A consumer is getting a phone today. All of us know our Dhobi, our domestic servant also carries a mobile today. We must take that note. Therefore, when we are interpreting law, we can't even look at that as partition set. It's not in a burqa. I must look at reality of life and then interpret law. It is possible that somebody might have done a mistake. It's possible. Otherwise, reformation will never come in. You can't reform only by imposing, take a barrel in your hand and reform somebody. You can always reform somebody with love, care, and tell him what is the requirement of law. And I think it's absolutely right what Mr. Mehta said. Most of us don't even know. And many of us know also and keep our eyes shut. Like, pigeon keeps his eyes shut and says, cat will never be able to see me till the cat eats it away. The problem is this today, that we as professionals do not advise our people the way we should do. I must tell my client, this requirement is the requirement of law. This we must do. Because ultimately, what I have to ensure? I have to ensure that somebody else in the market is not deprived of this similar right. In fact, I don't think I should make a mention, but it's mentioning only for the purpose of bringing a fact before you. I have not in all this time in the career seen a concept called an essential patent. We brought that concept now. We saw that recently. As a principal counsel to European Union, I had the pleasure to argue that for the first time in Brussels, in the investment chair. A concept of an essential patent which is in your phone, mobile. 140 patents in your mobile. And now, what is being said? Though under the terms are called FRAND terms, yet I arm twist everybody to say, please pay me this much money. And sir, you will consider it in your appropriate forum. But please look at it, that he wants me to pay royalty not on his patent, but on the entire phone, which has customs duty, which has sales tax, which has income tax, which has other liabilities of mine. essential patent when first time one argued in an Indian court. The judge said, what? What is the essential patent? Patent is a patent registered under the Patents Act. But a new concept came, that here is an essential patent where you can't claim monopoly. You must give license to people who comes to you on friend terms. That means reasonable terms. What else it is? It is competition. This is a facet of competition law, that you allow people to use that innovation which you claim you have done. For what? For the betterment of people. So that that patent which gets utilized in your instrument reaches to a common man. The purpose underlying this whole thing is one. It's nothing to do with anything else. I have only to ensure this competition under the competition law, to ensure how do I grow the economy. How do I tell people that when there is more competition, better thing will come in. Maybe I make a product, my friend Mr. Chawla may make a better product, and we both compete in the market. That's the word that we need to put in. So this concept of essential patent, when it came to the court started looking at it differently. I don't think ever in my little career I've seen essential patent being argued ever in the. Look at the change of all these laws that you've seen. If you see only the history of Delhi High Court, for example, in 1960 the court gets established. We're going to be 50 years old on 31st of October 2015, when we begin our 50th year. We started with IPR in a very small way, but today 62% of the judgments of the entire country are delivered by Delhi. It's a proud moment for us. And not only this, I must tell Mr. Chawla, I think he and his team must be proud of this fact. When speaking at Lincoln's Inn about a month ago, a question was put to me, what do you think about your CCI? And I only said this, I wish you could come and see the role CCI has played into the economic trend of that country. How many creases it has ironed out, how many messages it has sent to the industry, what you need to confirm. Therefore, people have started looking at you. Please take care of this position, it's very important. I may also add here that a day came which was probably 2013, one morning, from 7 o'clock in the morning till 11:30 at night, 7 countries of the world asked me judgments of Delhi High Court and Supreme Court of India. It's a proud moment. It's a new judgment that has come from Pakistan, if you see, with respect to the basic structure of constitution. I think this is Nasir, probably heads that bench. He quotes extensively Indian law on the basic structure of constitution. And I'm sure the CCI will be proud of the fact that when figures got presented by me of your CCI's role in the Indian industry, I had a thumping applause from the audience. That I feel proud because I belong to you, sir. But unfortunately, in my own country, I don't get that applause. Why? And I must thank this institute for bringing this all of you together to learn what competition law means. I wish each bar association, the bar councils of the country, or other professionals for that matter. And I do not know whether I will share that view of Mr. Mehta that we are the best professionals. We are nobody today. We must blend with each other. Let us stop this partitioning between company secretaries, lawyers, A and B. We all must strive together, rise together. This country needs us. And I can assure you, without the blending of all professionals, accountants, chartered accountants, company secretaries, lawyers, you alone are the sunshine of this country. You alone will be able to provide every sunshine. All darkness will go away if we all blend together to see what we have to do. Because after all, what will you do? A lawyer will tell you what kind of agreements may trouble you tomorrow before CCI or for any other court for that matter. I can give you an example of something very funny that happened once. The government had an agreement. The agreement says exploration. And exploration said, if the law governing is Indian law, the arbitration is English Arbitration Act. The procedure of arbitration is the ancestral law. the place of arbitration in Malaysia, but nobody will claim contrary to Indian law. I couldn't understand what you mean here. So the fact of the matter is that we are running from London because English Arbitration Act. We're in Delhi, we're in Malaysia. So all this expenditure, the point that I'm making is different. All this, I have no difficulty going up and down. My meter is on, there's no problem with those issues. But that's not the issue that I'm raising here. You became lawyers, you became professionals, not for money, but bringing something new to the society, bringing harmony to the society. And I may tell you, for every professional, he may be any caste and creed, his first religion is what he does to his brief. And if he does to his brief what he's supposed to do, not only look at his brief from a computer point of view, his greatest prayer is already done. He has done his prayer, irrespective of what caste color he is. Because ultimately, what is he doing? He's actually bringing to the door of justice. He's bringing harmony. If all my agreements were not the subject matter of CCI, they will start thinking whether we should have all the members or not. They will have no work. But that won't happen because we don't do our jobs. So it's not that, please don't misunderstand me to say that we are incompetent. We are not incompetent. And my firm view is India's talent can't be matched in any part of the world. Nobody can match us. Whether it's drawing, whether it's arguing, whether it's making submissions. Enron would have been a different argument, different case in this country, had your Indian lawyer not stood up there to say, I'll argue this case, and came to the United States to settle the matter with India. It's only because of this. But unfortunately, we all stopped assisting each other. I've started looking at partitions. Therefore, this act which has come, though 6 years old, look at the statistics my friend has already given me. We have gone a long way. We have brought to the people what compliance are required. And if compliance becomes, I don't think economic growth is anywhere further away. Economics will only come when we comply with that law. We have more competition with each other. We are able to bring more people. And look at the population of this country, which is so young. So if I was to throttle competition, then what will I do? In fact, if you go to any cafeteria today, come to my High Court and I'll show you. Come to my Supreme Court, I'll show you. People like me with white beard are few of us. Most of us are youngsters. So I have to bring that inspiration in you to see you're not meant only for your meter to run, you're meant for something more than that. And that actually is the theme of any judicial pronouncement, any judicial structure, any judicial enactment. I must ensure that I read that statute. Most of us don't read it today. I read 4 judgments of CCI and start up doing my argument. That's not the position. My fact may be different. And each provision will be different. Each provision can be argued differently. And we had a Vishwanath Shastri, one of the very eminent lawyers of the country, went to Supreme Court one day and his junior was not there with the brief. And the Supreme Court said, where is your brief, Mr. Shastri? He said, no, please pick up the statute first. He read 3 sections of the statute and argued 4 ways. By the time the brief had come and says, now my facts of the case are this, and apply them now. So the point that I'm making is, we need to be original. I can't be copycat. I need to look at my statute, my facts. And if we do our job, insecurity will come to CCI, because they will not have nothing to do with us then. And I must tell you, the little experience that I have of CCI or of the appellate tribunal, it's been tremendous, it's been fantastic. Look at what you learn. You learn contract law, you learn competition law, you learn so many other facets of law. By one matter, you learn yourself to something like that. Therefore, what are you actually doing? Your contribution to the economics of this country is only one, that we must ensure compliance by our clients. Compliance will only come when we go to read this statute and see what can be done. In fact, I have said that. My Mr. Bhatia is here, who had given me this honor to argue that matter, and I have said it is possible in law. I am saying so again. Dominance is not per se fatal to this statute. It's the abuse which is fatal. It's the terms of your agreement which are fatal. Therefore, Please keep that in mind. Once you comply with these two situations, economics will always grow. Growth is in our hand, not CCI. Let's put our hands together, blend our professional skills, and ensure if we do these compliances, make our clients compliant to the statutes, not only of competition law, but all other statutes. I'm sure things will be better, the economic front will be better, you will be better, I'll be better. And please look at something more important than that. This law, which is 6 years old, needs to undergo more changes, more interpretations. As I've just given you that matter before the honorable members of the CCI today of the essential patents today, we probably will get many more situations that will come. The things are changing, the world scenario is changing. Therefore, we must upgrade ourselves. And I must thank again the Institute for organizing this, to at least apprise their members what competition law of India is. Thank you very much for all this.
Thank you, sir. That's why I said there's no competition. In fact, Mr. Chandiok has recently been awarded as the Legal Eagle of the Year 2015 and also been recently awarded 2 honorary doctorate degrees as well. Thank you, sir, for sparing your valuable time and giving the entire paradigm and the entire coverage of the competition law and the basics, what we must keep in mind. Friends, now it's the time for us to listen to the chief guest for the day, Mr. Ashok Chawla. Before I invite him, I would read his brief introduction, which I am duty bound to do. Mr. Chawla, before his appointment as Chairman, Competition Commission of India, has held various appointments, including Chairman of Government of India Committee on Allocation of Natural Resources, as Finance Secretary, Secretary of Department of Economic Affairs, Ministry of Finance, also as member of Board of RBI, alternate Governor for India on the World Bank. Mr. Chawla has also had appointments in the corporate sector, including Chairman and Managing Director of Indian Petrochemicals Corporation Limited and Director of ONGC as well. We request you all to give a big round of applause for Mr. Chawla.